Good afternoon, ladies and gentlemen. My name is Lenka de Mauro. I am Head of European and International Affairs at the German Insurance Association, and I would like to welcome you to yet another virtual discussion in our GDV Live series. Today, we discuss the very topical issue of how to secure effective data protection in global business relations. I am very happy to be joined by three outspoken experts on the matter: Renate Nicolai, Moritz Körner, and Philipp Reiter. A very warm welcome to all three of you, and thank you for discussing with me today. I will introduce the speakers in due course, but before we start, I'd like to invite the audience to join the discussion by sending your questions and comments on Twitter by using the hashtag GDVLive, and on LinkedIn via the LinkedIn event page, where you can also follow the event. Now, talking about data protection in international business relations, we will, of course, address in particular the situation that emerged after the so-called Schrems II judgment of the Court of Justice of the European Union. But before we dive in the post-Schrems II world, let's say, I would like to have some first initial thoughts on where we stand on European data protection 3 years after the start of the application of the GDPR, and already a year since its first review. Renate, the Commission often praises the GDPR as one of the legislative successes of the EU. Hence, I'd like to start with you. Renate Nicolai has been since 2014 head of cabinet of Věra Jourová, who is currently the Vice President of the European Commission for Values and Transparency, and was previously in charge of justice, consumers, and gender equality. Before that, Renate served in several political positions in the fields of trade and international relations. Hence, data protection, trade, international relations, I guess there is not a Commission official who would be better placed to address today's topic than you. Therefore, can we have your initial thoughts on where we stand on European data protection from the Commission's perspective?
As a Commission official, you will not be surprised to hear that I maintain my view that we did the right thing with the General Data Protection Regulation, that we reformed it a couple of years ago, that we did it at the moment where this was not yet the kind of on the radar screen of everybody in the world. We were really pioneering at the time to kind of come with our revision of the data protection rules, and we did the right thing, because what we have achieved is that we have set a global standards. I mean, what we really see in the world, that there are many, many member states, around us, states around us. There are many alliance partners in the world who are thinking about modernizing their privacy rules, because that's quite important in the digital transformation we live through. And when they are looking at it, they actually take inspiration from the European model when it comes to enforceable rights, governance structures, supervision, independent authorities, so the basic principles that we stand for. That doesn't mean that everything is perfect. As we have clearly said in our review, which we published last year, which was 2 years after the direct applicability, we had a overall positive kind of, conclusion, but we also said there's more work to be done. And I think that is still true. I think we have to continue to explain it better, especially when it comes to the small and medium-sized enterprises, because they still feel that, there's too much burden on them. I think we dealt with a lot of the myths out there. And I think the data protection authorities helped a great deal to explain what hasn't changed and what has changed. I think also when it comes to the governance structure, which was probably the most innovative thing that we did, because we moved away from, 27 different things to a uniform, harmonized approach. That is only possible if there's a real common culture on data protection. I think I see much more development towards that, but we are probably not yet fully there. The data protection authorities really have to become the club and make full use of all the cooperation possibilities that are out there. And the third point that I would add is that we still have to prove also to the citizens of Europe that this modern data protection regime really has teeth. And that's why I think the next litmus test for the data protection rules is to really show that there is effective enforcement everywhere. And that, I think, is something that we will have to observe, and that will determine also on how we talk about the general data protection rules in 5 years' time.
Thank you very much. Thank you for quite comprehensive and very fast view. Thanks for that as well. Moritz, now I'd like to turn to you. Moritz is member of the European Parliament since 2019 for the German Free Democratic Party, From 2017 to 2019, he was member of the Landtag of North Rhine-Westphalia. In the European Parliament, he has been serving on the Committee on Budgets and the Committee on Civil Liberties, Justice and Home Affairs. He is also author of the podcast Europa, wir müssen reden, so Europe, we need to speak, in which he explains the Brussels topics and routines to a broad audience. The recurring themes there are rule of law and fundamental rights protection online and offline. Moritz, what is your perspective of somebody, let's say, who joined Brussels relatively recently, so to say, with fresh eyes on data protection in Europe? Thanks.
Thank you. I can only underline what Renate Nicolai just said. I think GDPR is a gold standard. We see that also as members of the European Parliament. I was in a delegation to the US of the Civil Liberties Committee before the Corona crisis hit us, of course. And even there, they absolutely are aware of the situation. Even in California, there's a data protection law in place. And they also took the example of the GDPR. So this process that we as Europeans with a big common market set standards and rules, that's absolutely a success. But I have to be a little bit stronger on my judgment on the enforcement. I think we really have an enforcement problem. The main problem here is that the small and medium-sized companies tend to be controlled very well by their national authorities, but we really have a problem. And I want to be very clear here. One of the main problems is the DPA of Ireland, where the biggest and digital companies are residing. And we see that there are nearly no cases at all, and closed cases especially. So I really see a problem here. We have been in contact as the European Parliament also with the Irish Data Protection Authority. And maybe you saw some news there. It's a quite difficult relationship. But I think it's really crucial if we want to live up to the ideals the GDPR sets out. We have to make sure that data protection is especially, and privacy is especially protected when it comes to the big platforms, the Facebook, Google, and so on. And we really need to have a unified enforcement in Europe. So that is where we have to be better and become better in Europe.
Thank you. Well, now to close this first sort of initial round, I'd like to give the word to Philip. Philip is the Group Chief Data Protection Officer at Allianz. In this capacity, he advises the Allianz Group on all privacy and data protection matters globally. Philip and his team are also in charge of designing and implementing a global privacy program. He previously was active as Executive Director and Global Lead for Data Protection and Management at UBS in London. And prior to that, he worked with the law firm Freshfield, specializing in IP, IT, and data protection. Well, Philip, could you give us some practical insight? Has the European data protection as introduced by the GDPR become routine in companies? How is the situation on the ground, so to say?
Yeah. Thank you, Lenka. And again, here I'm in agreement with Renate and Moritz. I think that GDPR has really been a success story, right? And as Moritz been said, copied in California, but also recently, in Brazil with the new data protection law. And, I come from a global company. As you may know, we're an insurer, asset manager, active in over 80 countries. So obviously not only the EU, but again, starting with the EU, this harmonization approach was very valuable for us. And for our international data transfers, we got the approval to have them done on the basis of binding corporate rules, as you know, also an instrument of GDPR. So this is all great news. But similarly to Renate and Moritz, I also see, room for further improvement here. I mean, time has moved on. And I think, as Renate also said, you know, especially from a business now, the focus is on digitalization. And as companies, we only have a successful digitalization if the consumers really trust in the data processing, right? And that comes then, you know, to the problems with enforcement, international data transfers, what we said. But on the other hand, you know, we also have to be careful not to hinder too much, you know, the data as an economy. And I see a little bit to make one example, you know, with the cookies, right? So we all have now hopefully compliant cookie banners, but there is a little bit of fatigue of this, right? This constant onus on you know, consent, where people are consenting then anyway. Perhaps we need to move something like where we have all a digital identity, where we set our preferences once and for all, and all the companies and governments then have to respect that. Another example is anonymization, right? So companies like mine, you know, we want to do a lot with data, but we don't necessarily need to know which individual is behind the data. So if we achieve anonymization, you know, we are usually out of GDPR, but the devil is in the detail. As you know, with big data and technology means there's now a big risk of re-identification. So we need to get the anonymization right. And exactly, Renate, when you were speaking about, you know, further reforming, developing the GDPR, I think these modern concepts, you know, will become important, right?
Thank you very much. Well, this sets, I think, very nicely the basis for now, let's say, the core of our discussion, the data transfers to third countries. Let us then and speak about the post-Schrems II world. In its judgment in July 2020, the ECJ invalidated the Privacy Shield, a bilateral agreement between the US and EU, which was applied since 2016. The reasons were briefly, the US doesn't provide for an essential equivalent and therefore sufficient level of protection as guaranteed by the GDPR. The legal basis of US surveillance programs are not limited to what is strictly necessary and allow for a disproportionate interference with the rights to protection of data and privacy, since they do not sufficiently limit the powers conferred upon US authorities, and there is a lack of actionable rights for EU subjects against US authorities. Renate, I'd like to start once again with you. Could you describe the Commission's reaction, and could you give us some insight into where the Commission is now in its work on the follow-up of the judgment, and maybe also, well, I know you don't have a crystal ball, but how likely is that we will find a successor for the Privacy Shield in the near future?
I was also involved in the Privacy Shield negotiations. And I would like to start by saying that at the time when we negotiated the Privacy Shield, it was a slightly different context. At the time of the Privacy Shield negotiation, we were hit in October 2016 by the Schrems I ruling. This was before GDPR. This was before, you know, we had the board of data protection authorities. And this was at a moment where there was no kind of solution, what else to do. Since then, I think we have seen several developments. First of all, we have established new data protection rules, which we just talked about. Secondly, we have from the European Court of Justice, not only one ruling on data protection. We have a stable jurisprudence. One could even say there is a constitutional jurisprudence on data privacy as a fundamental right on the basis of the GDPR. And we are also dealing with rule of law. So, you know, this is something we will definitely have to respect. And of course, in the meantime, we also saw some developments on the US side. I mean, it was already mentioned by Moritz, there are several several states who have kind of, individual data privacy laws. I remember myself in the last mandate with the then Commissioner Jourova, we were actually engaged with the Congress at some stage where there was hope for even a federal privacy law that then kind of, disappeared a little bit in the run-up to the last presidential elections. But so there's movement on all sides. Mm-hmm. What we have now is a situation that is uncomfortable because Privacy Shield was a very good solution for companies. Philip was saying that Allianz has kind of developed the binding corporate rules. That's great, but that is also very useful for a global player like Allianz, but that doesn't work for, small and medium-sized enterprises, all over Europe. So, adequacy decisions as such remain an important aspect of our kind of, diplomatic efforts to kind of, work on data transfers, which are so important if we want to bind ourselves economically more closer with alliance partners. Like we did in Japan, we negotiated free trade agreement and parallel to that, an adequacy deal. Did the talks have restarted? It's Commissioner Reinders who kind of leads on that with Secretary of Commerce Raimundo. The teams are in direct contact, but I would say the kind of the mandate that we have as European Commission to kind of, engage with the United States on that is very, very clear. And is clearer, I think, compared to where we were at the time of Schrems 1. I think this is also clear for our American partners. I'm very positively surprised because we are also quite, involved in that, as partner with the team in the DG because we are the coordinating vice president team. I'm very surprised and positively surprised by the engagement of the Biden administration on this. I think there is really a common interest to kind of, show, close cooperation on the broader issues of digital transformation. And I think that's a very good sign by the devil in the details. And so I don't have the crystal ball, and I wouldn't want to promise something quick and dirty, because what should be our guiding principles, and that's why I try to explain really the difference compared to 2016. It was a really different context. I think this time we should not risk a Schrems 3 ruling. And hence, there are real issues about, how you limit the access for national security purposes on the US side, what safeguards we really need so that the concept of our proportionality is met. And also, how can we ensure effective redress for the individual? And this is something that is, from where I sit right now, very hard to imagine without any changes in the legislative system in the US. Knowing the US a bit, that might take a little time. So much from me on that.
Thank you. Well, Moritz, you mentioned already your visit or your travel to the US on this matter, and you have been also very outspoken on this matter in your public statements. What is your take on a possible Privacy Shield 2, and how do you assess the probability of the US administration moving sufficiently to make this happen?
So first of all, it's good to hear that the Commission is not going to do it quick and dirty. I think maybe Privacy Shield was already a little bit quick and dirty, and we in the European Parliament, I was not member of the European Parliament then, but we warned and we always said we think that this will not hold before the European Court. So I hope we will not have a privacy safe harbor shield or something like that, but really something that is Schrems proof that really is in line with the two ECJ judgments. I heard already yesterday that the Commissioner Jourova clearly said she also thinks that there's a need for legislative change on the US side. I absolutely welcome this position of the European Commission. We also, as the European Parliament, in our resolution on Schrems 2, we called for legislative change because we think that this is the only way to have really a solution. If there's no change in the mass surveillance and security system of the US, we think that it's very likely that any other agreement would be struck down in front of the Court of Justice. So we really hope that we will achieve something, and I think the situation is as Renate also pointed out, it's different. Not from the timing. It's not only the Biden administration, I think, which is really helping. We know that the Biden administration wants to strengthen the ties between the EU and the US, but also I think the perception of privacy and data protection changed in the US dramatically, and I heard that when I was there in Washington and Boston. First of all, I want to go to back to Trump. Even Trump warned and wanted to buy or to stop TikTok from working in the US because he feared that Chinese intelligence services or authorities may have access to data of Chinese of US citizens. So actually, this fear Trump put forward, we actually absolutely know that for US surveillance services. So maybe we will find some more common ground, and I would be really happy because I think we really not only to have a stable transfer between the EU and the US, because data transfers are very important for our economy, but also in view of China and in view of the changing situation of privacy, we need a global standard. We need to work together with democracies and allies around the world to protect privacy and achieve data protection. And I think maybe if the Commission is doing it right, and after the statements by Commissioner Jourova, I'm absolutely more hopeful that we will achieve something there, and then maybe that's a good start for a global standard, maybe a Western or a democratic standard on data protection. That would be really something we want to achieve.
Thank you very much. Well, I'd like to turn now again to Philip. Philip, I have to give you a technical remark. I think we have a problem with your camera and see you in a horizontal mode. So could you move your camera so we see your picture vertically? It was just a remark from the. Okay, well, I hope this now works. I'll see whether I have the thumbs up from my colleagues. But now I'd like to come to the question to you. So how are companies dealing with this situation now? What can they do and where do they face difficulties? The European Data Protection Board has issued some supplementary recommendations. The European Commission is about to adopt standard contractual clauses. So what is the situation on the ground now? We don't have a privacy shield anymore. We need to deal with the US platforms that have been mentioned by Moritz before. Is that situation manageable for you? And what would you need if what is there is not clear enough, let's say?
Yeah, thank you for the question. First of all, I hope I'm now in the right angle. I didn't change anything, but no, this is a very good question. And, I also agree with Renate and Moritz. I'm also concerned with data protection levels in China. And I also agree, with the assessment of the Schrems decision. However, the outcome of the Schrems II decision is really a headache for businesses, Allianz or other global or even SME companies. Because, as Renate has hinted, it probably will now take a long time to get really an agreement with the US, and perhaps, they need a federal data privacy law or what have you. It's not even clear what's coming, or also what Moritz said, do we have something like Convention 108 globally with China and India, right, as a big IT service location. But till then, I feel really, the Schrems II decision and really the European Data Protection Board has put the burden on the companies. Because what we really now have to do is, do an assessment on the countries where we're sending the data to, right? And the Commission usually takes sometimes years to do these assessments. So we have to do these very quickly and then, take a view, is it acceptable that we send the data there or not, right? Mm-hmm. And for companies even of the size of Allianz, it's really a lot of work. But it's not only the work, because if you really read the recommendations and take them seriously, what we obviously all should do, we are bound by law, that often means we cannot transfer any personal data to the US and other countries anymore, right? But then a company like Allianz, we have employees all over the world, so we need to transfer employee data, but also it's clear that most of the IT service providers, take Amazon Web Services or Microsoft are US companies. I mean, they may have, European clouds, which we are using, but yet they're servicing, these clouds from the US. And even if they don't do that via the US Cloud Act, they potentially have access to the data, right? And potentially then if you apply all this by the letter, the European Data Protection Board recommendation, then that would lead to a standstill of data, right? Till this political agreement is reached. But now, our customers want to have the services, our employees will get paid. We all want to have, perhaps social media things, right? So we need to move on. And that is the pain, I'm in several industry associations, most companies are at. So, and that is also where companies like also our association, which is inviting today the Association of German Insurance, have said, yes, we as insurers or companies as a whole, we are doing this analysis, but let us also do a risk-based approach, right? Where we don't go so, black and white, we transfer data or we don't. Let us look, what data is involved. Is it just email or is it perhaps health data? Can we protect it, maybe encrypt it, that the provider cannot read it, or pseudonymize it, that the provider don't see the real identity behind the data? So I think that is our proposal, now for the EDPB, but also, for the new standard contractual clauses to come for the EU Commission to have a very practical yet compliant approach here.
Mm-hmm. Thank you. So the industry is asking for, let's say, for pragmatic solutions at the moment. Moritz, can I have your reaction? Is this doable for you? And also, could you give us an insight into the discussions you had in the Libe committee when drafting your Schrems II resolution? You discussed some of these approaches, for example, risk-based approach to what data might be still possible to transfer and so on. Thank you.
Yeah, I absolutely understand that it's a big problem for the industries, for small and medium-sized companies. I know that, and we know that, but we think the big problem is, or the even bigger problem was, if we not do, a post-Schrems or a post-Privacy Shield agreement wide, and we would again come into the situation where we have another ECJ judgment when all the companies just started to organize themselves in the right direction, and then they again need to organize it in a new way. So we see this situation, but for me, and I also talk to lots of small business, they say, we made everything happening, and we were relying on this, and now we are in this legal uncertainty, and this is actually the big problem for us. So we try to call on the Commission to be very clear and have a really bring something forward what is absolutely Schrems proof. And that's what we try to focus on. And I know that there are some groups in the parliament maybe who are not so much on this line and pushing for, we need to go forward faster and so on and so on. I think that is even that is not really reasonable towards business, because what we don't need is to go back again in this uncertainty situation. So we really need to do it right this time. So all good things are three things. So maybe we get it this time.
Mm. Very well. Let's hope then that the Commission is so strong that we arrive at a good, lasting solution. But still, I'd like to come back to the current situation and also ask Renate what the Commission is, the Commission's position on this, let's say, intermediate solution is. Of course, well aware of what the EDPB has said and also the resolutions of the EP. And also more specifically, we are awaiting very soon the standard contractual clauses by the Commission to come out very soon. So is something like a risk-based approach in there incorporated? Can we expect that? What are, let's say, what is your guidance what is the guidance to be which we are to expect from the Commission for the moment? Thanks.
Yeah, thank you. I think that as a Commission, we have heard the calls that there needs to be at least also an interim solution that is, feasible. And since we now have the setup with the GDPR and the Data Protection Board, we were in a position to actually move much faster. And that's why, indeed, the standard contractual clauses, both between controllers and processors, but also for the data transfers, they are around the corner. They are about to be adopted. Of course, we had to hear, this is a comitology procedure, as you might know, and this we had to hear and take seriously the remarks on that by the Data Protection Board, also by our Data Protection Supervisor that looks at all our actions in the Commission when it comes to data privacy, and also the member states, frankly. So I'm confident that what will come out is a practical tool that will help to at least, pave the way for the time now. We should not forget that in the Chapter 5 of the GDPR, we have, for good reasons, different modes of transfer, because there will always be countries in the world with whom an adequacy decision isn't even imaginable. And that's why these other modes of transfer, be they binding corporate rules or standard contractual clauses, need to be taken seriously. But I also take the point of Philip that, of course, there's a much bigger onus on the companies, because, some of the assessment will have to be done by you. And then the enforcement side, the controlling side in individual cases will have to be done by the data protection authorities. So there's actually a double, adding of responsibility. And that's the charm of having an adequacy decision. But that's also why the standard is so high for an adequacy decision, that there, because we have for once, decided, of course, we keep on monitoring that. But if you decide there's an essentially equivalent level, then, you can just kind of, work on that basis, because somebody has assessed that, the data can travel with the protection along. And that will not go away. So that difference and just, the manageable way of the tool is not going to disappear. So, but I hope that you will find the standard contractual clauses, which, as I said, will come around the corner, are useful. And I'm personally quite proud. And I think it is an expression of the commitment and also the responsibility of all the actors, because that is not only possible because the Commission proposed it, you also need to have the others in play to play along. And this is for me really also coming back to the broader context of this debate. This shows again that, all the actors are in play, that the club of data protection authorities actually works and gets on the case and, brings about, the opinions, which is, we've come from different starting positions, and it's still relatively new that we have harmonized rules. And this in itself, I think, is a good message for businesses, at least to help that and to help us guide this in the middle future, in the midterm future, without kind of leaving aside the interest to come to bigger convergence. Be that now in bilateral kind of virus adequacy talks, or also just to kind of, echo what Moritz said earlier. I think this is also a moment in terms of the geopolitics to actually rally more those around the globe who have a similar approach to, what it takes to kind of really transform in a good way in this digital revolution and transformation, because, where we put the individual with his or her rights at the center. And this is what this is all about. This is about data privacy. This is about, the Digital Services Act. This is about, artificial intelligence. And I think here we have an interest in using also our weight as the standard setter to continue to aim for that broader convergence.
Mm-hmm. Thank you very much. Before I go to the next topic of the adequacy of with the UK, let's say a new third country to the European Union, I'd like to invite once again the audience to step in and ask questions or send us your remarks. I'll try to integrate them in the discussion as best as I can. Now on the adequacy with the UK, briefly, the decision by the European Commission is expected by the end of June, when the sort of grace period finishes. I'd like to know, Renate, how did the Schrems discussion influence this process? Are there differences in this adequacy decision to previous adequacy decisions with other jurisdictions? What was it more difficult? It's still in the process, so I'm aware that maybe you cannot disclose everything, but
the big difference between, this adequacy decision and others is that normally we come from very different starting points, and we try to converge more towards, something that comes closer to our model, so that we can say, following the Schrems kind of jurisprudence, or the ECJ jurisprudence rather, that we need to have an essentially equivalent level of protection. And of course, with the UK, it's because of the sad story that they have left, is that, we actually have a common starting position because they implemented GDPR. And I was in the machine room of the negotiation on the GDPR, and I know how important the role of the UK was with Tech UK and that kind of business approach and pragmatic, they helped us a great deal in kind of shaping the GDPR as it is today. So, but, that's the starting position. And what we have to ensure in these adequacy, or had to ensure in these adequacy talks, is that we are kind of, prepared and can act in case they are diverging over time. So this is the kind of the challenge. And this is what we have done diligently, and where we have come to the conclusion, at least that's our starting position, that, with, for the first time building in a sunset clause, which we have never done in any adequacy decision, that we would, after 4 years, actually take a look and see, we would have to renew this process proactively, to see whether they are still there. I think this is quite a leverage to kind of, to push the UK to stay, for instance, when it comes to effective judicial redress, which we said is such a headache in our talks with the US, to keep the UK in the Council of Europe, Strasbourg kind of jurisprudence system where the individual can go and, address issues, for instance. And of course, there is in between the monitoring where we can at any time kind of, suspend, ask questions, as we do with other partners as well, in case there are deviations. So this was our starting position. We have seen, and Moritz will for sure comment on it, what the Parliament's position on that was recently. On this, we differ. But on the other hand, we will, of course, now kind of take a look at that. We also, in the adequacy decision with the UK, have worked very well with the Data Protection Board. They also had views. They did not come to the same conclusion as the European Parliament. They had views that we incorporated. So I maintain our general direction that, I don't see any sense in having kind of a strong TCA, a trade and cooperation agreement with the UK, and then not an adequacy decision, if the situation is right. Of course, we are looking into this now, also in light of the resolution of the Parliament. It's of course not binding, we're in comitology, but nevertheless, I want to stress that there's also an issue of coherence here. Because as a geopolitical player, if it's not even possible for us with regard to the UK to say that, the starting position is such that, we should be okay. What does this mean for the feasibility of adequacy, from an EU point of view? But I also wanted to, bring in some dissent here.
Yes, well, and I think I don't need to pose the question, so just please, Moritz, react on.
The good thing for Renate, as she already said, the Commission has only to take it. Our resolution on this is not binding. That is first, the for us, of course, is the Parliament the bad thing. So it's just an opinion we can give. And I don't want to say don't want to have an adequacy with the UK at all, but we raised some doubts that this adequacy decision is yet doable, and we call on the Commission to still negotiate with the UK side, because we also, again, I'm thinking of the small business who would rely on the adequacy decision, and then Mr. Schrems again is taking up this adequacy decision, and we are in this situation we already know. The problem is, and I absolutely agree with Renate, of course the UK they have the GDPR, and we are very close in this regard. The only thing I see is the mass surveillance. We know that the UK side is using a mass surveillance, and we know that within the EU that is national security, so it's not a competence for the European Union, but maybe it's really it's a strange situation, but now it can be subject to the ECJ ruling, and we fear that we have problems there. Also, maybe the migration exemption, there was a ruling in the UK also on this issue. So even there are problems. We see this also for European citizens. So we wanted to raise that, and I think, so this is my personal view, maybe also as a young MEP, but now here for 2 years. It sometimes, the Parliament, especially when we are not in a classic legislative situation, we need to send maybe a stronger signal to the Commission and to the member states. And I think we did this with the resolution, and we clearly warned. And if the UK adequacy, I think I'm pretty sure that the Commission is looking into our opinion, but will go forward with the adequacy decision. But if there are problems, we as a Parliament at least raised it, and I think that was really important for us, because we are talking about this with the two Schrems decisions and so on for such a long time, and in the Parliament the majority was always very clear on this, and I think this was of course then the consequence we had to do on this resolution. I know that it was also heavily debated within the Parliament, but it got a majority, and we hope that the Commission still tries to get an even better result with the UK side.
Thank you. So, well, a lot of caution, although coming from the same basis, same ground, but a lot of caution in view of the previous development, which I also understand. Of course, also from the position of the industry, I think the last we want is further legal uncertainty. But still, Philip, what would be your take on the adequacy decisions with the UK, but also other countries like, for example, Canada, Switzerland, or Japan? For how important are they for you?
I mean, as a colleague said, right, the adequacy decision is super important because now the contractual clauses after Schrems 2, right, they often don't help us. As explained before, we have to do a case-by-case analysis, which we don't have to do with an adequacy decision. But I really hope, the adequacy decision for the UK is coming, right? I mean, we have a significant business there, and we hope, we can exchange services. And, also knowing the UK, for example, they have an amazing data protection regulator, the Information Commissioner. It's always been very known for very thoughtful, practical guidance, yet enforcing, right? You've seen the big fines against the Marriott hotels or British Airways. So other Moritz, and you said in Ireland where we didn't see that, but in the UK you did see that. And the UK also has an exact copy of the GDPR, the UK GDPR, which is a law there now, right? And I also appreciate, and I've read about the surveillance in the UK, but, I also read something similar going on in France, right? So I think we also need to look a little bit at our own house, our secret and police services, what's going on here before pointing at others, right? And then Lenka, Switzerland is also a very good example, right? So we have very tight business ties with Switzerland, and there the adequacy decision has worked really well. As you know, they are also now reviewing the Swiss Data Protection Act. So I hope the adequacy decision remains. And I mean, I understand, Renate, that, it's a careful, right? Because if you give such a blessing to a country, you want to get that right. But perhaps, I could also encourage the Commission here a little bit to come quicker to these decisions, right? Because we, as a business, are really depending on these. But as I said, for the UK, I'm hopeful that it's remaining with the adequacy decision forthcoming.
Thanks. Well, there have been some, let's say, new insights in this round, but unfortunately, we need to come to the closing fast round, maybe, of your closing remarks. I'd like to ask you for, as, let's say, short an answer as possible, although the questions are very complex, I understand. So, Moritz, what, in your view, can Europe do to ensure a high level of data protection without falling back in digital developments?
I think being better on enforcement, we already talked about that. Completing the discussion on e-privacy, the little sister of the GDPR. This is going on for a long, long time. And I hear, and I want to say that if the Commission is doing things right, I also loudly say that the Commission is really asking publicly for the US side for legislative change. That is, I think, a very strong signal. I absolutely fully support that. And if we can go further in international transfers and really try to work more together with our partners who share the same view, that would be a very good starting point. Maybe after all these Schrems and judgments and everything, maybe we find a common line together with our partners. That would be my hope and wish, and I only can wish the best and all the power for the Commission in the negotiations with the US side.
And thanks. A similar question to you, Renate. So what, practically, maybe you already also answered that, but where do you see the future of the European way of data protection, and where do you see the most urgent need for action?
Maybe something that I observed in the COVID times, that, actually the COVID times has shown that, data protection can also be an enabler in finding solutions which are privacy by design solutions. I mean, if you take now the most recent example, the COVID certificate or the tracing app, I mean, these were measures which were really important to kind of allow us all to kind of within limits, but still enjoy our freedoms. But of course, we had to do it in a GDPR compatible way. And I think that's exactly what I think we have to show also in the future, that what we have kind of established with the GDPR is really future-proof. I think, in the COVID times, it has shown that, even if a stress test is put to it, you come with things that have not been foreseen because nobody foresaw that kind of pandemic kind of situation. We can act. And also, as I said, I want to come back to that. The Data Protection Board was ready to act. I think Philip also mentioned an important point. We have built in, and I remember the talks very well, these kind of future-proof techniques. But of course, that's already a century ago, if you kind of think in terms of the technological development. So I think all the kind of things of anonymization, pseudonymization, kind of how AI and data protection can get along. So I think that's a kind of an important area of work that we need to not lose sight of, so that we also kind of stand the test of this future-proof element of GDPR. And, enforcement, that's the third point indeed. And I mean it, because, I've been also very involved in the making of the DSA and the AI Act. And what you see, when you take a close look, we are coming back with the board systems, but we also give a slightly more central role to, the commission or structures. So a little warning, if the decentralized implementation and enforcement structure that we have pursued in the GDPR with the board, but all the kind of decentralized enforcement in all the kind of, member states, data protection authorities, if we see in a couple of years' time that this is not working or not delivering to effective enforcement because, the procedural rules differ too much, some are too slow, it's a resources issue. I can only warn that there might be an appetite for coming with a more centralized approach. And that's, I think, something that is a good wake-up call for all out there, who have to enforce it on a day-to-day basis, just to make sure that they actually deliver, not only on working together, which is great, but also and showing the team with clear enforcement actions.
Very well. We are very much awake, and I think everybody around Europe as well. Philip, from the perspective of a globally active insurance company, if you had one wish to express in this situation to the EP and the Commission, what would be it?
Yeah, I think we've discussed extensively international data transfers with risk-based approach, right, and the needed political solution, but also the modernization of GDPR, but also what Maurice said, now finally come up with the e-privacy regulation, right? Germany has now passed the e-privacy national law, right? But we need something on the EU level. But the bigger wish would be also, to have a more holistic view on data. And I think the EU has started that, right? We have proposals for a Data Governance Act, right? Which the other side of data, how to use data, also allow the sharing. But also Renate has mentioned artificial intelligence and big data, right? And I see these different initiatives, but my worry is also, how does that puzzle all fit together, right? Where do we adequately then, protect the rights of the citizens without, hindering business too much? So all great initiatives, but we also have to be careful that it all works together, a little bit like a clockwork, in a switch, in a Swiss watch, that all these components fit together. And I trust, with the Parliament, with the Commission, with the Council and the businesses, we can achieve that. but it's not an easy journey.
Thanks. Well, you have practically almost said what I would say in my very short closing remarks. So thank you very much. I think this discussion has shown that there is a lot of, first of all, there's a lot of movement in this field from all sides. As often the aims are shared by everybody, the way there is complex. And I look forward to discussing all these aspects with you at future occasions. But at the moment, I'd like to thank you for the lively discussion. Thank the audience for watching, and my colleagues for setting up this event, especially many thanks to Martina and to Konstantin. And I wish you a good rest of the day. Enjoy the sun. At least in Brussels, we do so very much lately. And speak to you soon, hopefully also in person. Thanks. Thank you.
Take care. Thank you.
Bye.